Hello and welcome to our channel. Today we are diving deep into the critical area of finance and law, the different categories of guarantees. If you work with demand guarantees, standby letter of credits or suretyship guarantees, understanding these distinctions is essential to avoid costly disputes and ensure clarity in your agreements. In this video, we will break down two main categories of guarantees. First one, independent undertakings, such as demand guarantees and standby letter of credits. Second one, suretyship guarantees and indemnities. So, let's get started. Understanding independent undertakings. Independent undertakings are demand guarantees and standby letter of credits are primary commitments. The issuer, which is typically a bank, is obligated to pay the beneficiary on demand, regardless of any underlying contract between the applicant and the beneficiary, where applicant is the party requesting the guarantee and beneficiary is the party who receives the payment. In similar term, with independent guarantee, the issuer's liability is not affected by any disputes or issues in the underlying contract between the applicant and the beneficiary. The bank's role is to pay upon demand, provided the terms are met, making these undertakings straightforward and simple to enforce. Suretyship guarantees. What made them different? On the other hand, a suretyship guarantee is a secondary in nature. Here is what that means. It is a secondary obligation and only arises if the applicant fails to meet their obligation to the beneficiary. This form of guarantee, also called an accessory guarantee or simply a suretyship, which requires the guarantor to pay only if there is an actual default by the applicant. So, unlike an independent undertaking, a suretyship guarantee is closely linked to the applicant's obligation under the main contract. The guarantor's liability will never be greater than that of the applicant, and the guarantor can use all the same defenses available to the applicant in the event of claim. Understanding the distinctions between two categories of guarantees is a fundamental of good practice in handling demand guarantees and standby letter of credit. The failure of banks, corporate customers, and lawyers to recognize the differences often lead to poor drafting and consequent dispute over the parties for their respective rights and obligations. At first sight, these two categories of guarantees may look similar. However, legal basis and practical operation of each category are very different. It is therefore important to understand the principal differences between them. We have seen that the independent guarantee, such as demand guarantees or standby letter of credit, is a primary undertaking by the bank in favor of the beneficiary. It is payable on demand. The obligation of the guarantor or issuer does not depend on the actual liability of the applicant to the beneficiary under the underlying relationship. By contrast, a suretyship guarantee is an undertaking by guarantor to pay to the beneficiary as creditor the sums due from applicant as debtor. A suretyship guarantee is a secondary obligation in that it arises only if the applicant has a legal liability to pay the beneficiary. The guarantor's obligation is no greater than that of the applicant. A suretyship guarantee may also be called an accessory guarantee, a suretyship, or simply a guarantee. The guarantor is sometimes referred to as a surety. Indemnities. Now let's talk about indemnities. Although similar to demand guarantees, indemnities have unique aspects. An indemnity is a primary obligation, meaning it is not dependent on the applicant's default. However, unlike demand guarantees, an indemnity does not simply pay out to pre-specified amount. Instead, it covers actual losses incurred by the beneficiary, and these losses must be provable. Some indemnities are open-ended with no cap or expiration, making it difficult for the issuer to manage their potential liability. Often an indemnity may be paid with suretyship guarantee to protect against certain limitations, combining both protective mechanisms. An indemnity shares some of the characteristics of the demand guarantee in that it is a primary liability and is not dependent on another party's default. However, it differs from demand guarantee in that it is not an undertaking to pay a specified sum or maximum sum on demand, but simply an undertaking to hold another party harmless against loss, the amount of which has to be claimed. The beneficiary must therefore be able to prove its loss. Some indemnities will not be limited to a specific sum, and some are not contain an expiry date. This presents the issuer of the indemnity with a problem that it may not easily be able to assess the amount of duration or its exposure. An indemnity will sometimes be occupied with the suretyship guarantee in the sum of the document under the title Guarantee and Indemnity. Since the indemnity will overcome some of the restrictions of the operation of the suretyship guarantee. That means some indemnities are open-ended with no cap or expiration, making it difficult for the issuer to manage their potential liability. Often, an indemnity may be paid with suretyship guarantee to protect against certain limitations, combining both protective mechanisms. To make this clear, let's look at a practical example. Imagine a contractor A has signed a construction contract with a client B. The contractor asks G Bank to issue a performance guarantee in favor of B. In this scenario, in a suretyship guarantee, the test might say, if A defaults on its obligation under the contract, we will pay up to $10 million. Here, G Bank's liability is limited to losses caused by A's default, making it suretyship guarantee. Indemnity. In a second version, the guarantee might say, we will cover any loss you suffer in connection with the contract up to $10 million. This language signifies an indemnity where G Banks covers B's loss up to a limit without needing A to default. Demand guarantee. A third version might state, we undertake to pay upon demand up to $10 million. Here, the bank's obligation depends only on B's demand, making it a demand guarantee. No proof of default is needed. The term of the demand are all that matters. So, in suretyship guarantee, bank's liability is limited to losses caused by A's default. And in indemnity, bank covers B's loss up to a limit without needing A to default. But for demand guarantee, no proof of default is needed. The terms of the demand guarantee are all that matters, where bank obligation depend only on B's demand. These small wording changes create vastly different obligations for the guarantor and rights for the beneficiary. Now let's see the characteristics of suretyship guarantees. Suretyship guarantees seem straightforward, but they have specific characteristics, especially under English law. First one, payment upon default. A suretyship guarantee requires proof of the applicant's actual default. The guarantor's obligation only arises if the applicant fails to fulfill their contract. The obligation to pay under a suretyship guarantee arises on the actual default of the applicant or debtor, not simply on the presentation of the written demand by the beneficiary or creditor. Some suretyship guarantee is payable on actual default. The beneficiary may have to prove proof of default. Limited liability. The guarantor's liability will never exceed applicant's debt. In suretyship guarantee, the extent of the guarantor's liability is no greater than that of the applicant. This entitles the guarantor to rely on all defences that are available to the applicant in relation to the debt, so that the guarantor is required to pay only the amount that the beneficiary establishes as being owed by the applicant under the underlying relationship. Continuing coverage. Suretyship guarantees may cover a single transaction or apply to future ones. A continuing suretyship guarantee can be terminated for new loans but remains in place for past transactions. That means a suretyship guarantee may be issued for a single transaction, or it may be continuing guarantee that will cover future transactions such as future loans or credit guaranteed by the beneficiary in favor of the applicant. If it is a continuing guarantee, the guarantor will normally have the right to terminate the guarantee so that it will not cover any new loans made after the date of the termination. But the guarantee will continue to cover the repayment of loans already made at that date. Requirement of validity. A suretyship guarantee must be in writing, signed, and often made as a deed or under consideration, ensuring the guarantee is legally enforceable. A suretyship guarantee involves not just an undertaking to pay any sum due from the applicant, but also to procure performance by the applicant of an underlying contract. Discharge of liability. If the original contract between the applicant and beneficiary is altered without the guarantor's consent, the guarantor's obligations may be voided. That means a suretyship guarantee is discharged if the underlying relationship is varied without the guarantor's consent. These features highlighted how complex suretyship guarantee can be, especially when they need to consider each party's right and obligations. Now let's discuss about deed. Deed is a formal legal document that must be signed and witnessed. Consideration. As a technical legal term, consideration refers broadly to the benefit and burden involved in exchange of promises. For example, in a contract of sale of goods, the consideration for the seller's promise to deliver goods is the buyer's promise to pay the price. In the context of suretyship guarantee, the guarantee may be referred to the guarantor's promise as being given in consideration of the beneficiary's agreement to enter into contract with the applicant. Consideration is not required in demand guarantee or standby letter of credits. You may often see suretyship guarantee in which additional provision has been added in order to exclude the operation of some defences, such as the amendment of the underlying relationship without the guarantor's consent. However, the presence of such exclusion in the text of the guarantee does not turn the document into a demand guarantee. Instead, it confirms that the parties intended the documents to be a suretyship guarantee, but with exclusion in relation to certain defences. If the parties had intended the documents to be demand guarantee, they would not have needed to exclude these defences because the defences do not apply to demand guarantees. Choosing the right guarantee type. If you are drafting a guarantee, you need to decide whether to use a demand guarantee, a suretyship guarantee, or an indemnity. Here is what you consider. First one, agree test. The applicant and beneficiary have specific wording. Be sure to understand these implications. Second, bank policy. Different banks may have policies favoring certain type of guarantees, and have to ensure the local practices as well. Certain countries may mandate suretyship guarantee for consumer transaction. In general, demand guarantees are often preferred because of their simplicity and reliability. Banks benefit from only having to verify compliance with the demand states without needing to assess the applicant's liability or the beneficiary's actual loss. In summary, understanding the distinction between dependent undertaking, suretyship guarantee, and indemnities can make a significant difference in managing guarantees effectively. The choice of wording and type of guarantee has legal and practical implications. So, it is crucial for banks, companies, and legal professionals to be well versed in these details. Thank you for watching. If you found this video useful, don't forget to like, subscribe, and hit the notification bell for more in-depth sections in finance and law. See you next time. Bye.